Okay, so who do we need tonight before we get into the formalities?
Is the applicant here?
Of all the board members.
Yes, I'm Philip Parry. I'm here to speak tonight on behalf of the DeHulus, and I'm not sure if Bill is available, and Dina, I see their icons up.
Yep, I'm here.
I'm here too.
Okay. And is Rebecca there, or are we waiting on Rebecca? I see she looks to be muted.
I'm here.
Oh, okay. And
yourself.
I'm all set to present. I don't know typically what your process is. It's been a few years since I've made a presentation of the Groveland ZBA, but I assume that that everybody's got a copy of the petition and any attachments that went along with that. So with that said, if the board would like, I would I can begin a presentation.
Well, we're going to work through some formalities of opening up the meeting, particularly with the remote, and get all the formal declarations covered. So we'll walk through that in a minute. I just want to make sure we get everybody we need to kind of at least proceed before we have all the members. We have the applicant. Is there anybody else? Rebecca, is there anybody else we need on our end that's not available?
I don't believe so. I think that like you said, the applicant and the board members are all present.
Right. Then I will walk through this script. First, I think we want to vote to open the meeting before we work through the remote script. Grab the agenda. All right, so I'd like to open the Wednesday, April 1st, 2020 Groveland Zoning Board of Appeals meeting at 7:35 p.m. Given that we are remote, I want to walk through some formalities before we get started here. As a preliminary matter, this is Jason Normand, the chair. Permit me to confirm that all members and persons anticipated on the agenda are present and can hear me. Members, when I call your name, please respond in the affirmative. Chris Goodwin?
Here.
I don't have to call my own name. Kathy Franson?
Here.
John Stokes?
Non's needed.
Unmute, John.
Yes. Yes, I'm here.
All right, just to confirm for sure for Rebecca, is that all? Can you hear everybody reasonably?
Yes.
Yes, I can. Thank you.
All right, and staff, we have Rebecca Olden, Cat joining us. And the anticipated speakers tonight, I'll actually let you each walk through and introduce all the members for the applicant. Just go through it again, even though you already went through it once.
And I'll start. I'm attorney Philip Parry of Parry and Parry PC in Merrimack, and I'm here for the petitioner.
I'll go next. My name is William Holt, and I'm the design engineer for the project. I'm here for the applicant to do rules.
Dina and Stephen DeHulu, applicants, we're both here.
All right. And we'll introduce public comments as we get more into open up the continuation of the meeting, but let me finish this out to cover all our legal details. Good evening. This open meeting of the Groveland Zoning Board of Appeals is being conducted remotely, consistent with Governor Baker's executive order of March 12th, 2020, due to the current state of emergency in the Commonwealth due to the outbreak of the COVID-19 virus. In order to mitigate transmission of the COVID-19 virus, we have been advised and directed by the Commonwealth to suspend public gatherings. And as such, the governor's order suspends the requirements of the open meeting law to have all meetings in a publicly accessible physical location. Further, all meetings of public bodies are allowed and encouraged to participate remotely. For this meeting, the Groveland Zoning Board of Appeals is convening by video conference via Zoom, as posted on the town's website, identifying how the public may join. Please note that this meeting is being recorded and that some attendees are participating by video conference. Accordingly, please be aware that other folks may be able to see you, and take care not to screen share your computer. Anything that you broadcast may be captured by the recording, and I'll add later distributed to YouTube and various other public spaces. All supporting materials have been provided. Members of the body are available on the town's website. We are now turning to the first item on the agenda. Before we do so, permit me to cover some ground rules for effective and clear conduct of our business and to ensure accurate meeting minutes. I, the chair, will introduce each speaker on the agenda. After they conclude their remarks, the chair will go down the line of members, inviting each name to provide any comments, questions, or motions. Please hold until your name is called. Try and be reasonable, but given that we only have a handful of people here, I think we can be a little more flexible with this. Further, please remember to mute your phone or computer when you are not speaking. Please remember to speak clearly and in a way that helps generate accurate minutes. Finally, each vote taken in this meeting will be conducted by roll call vote. And that brings us to the agenda. So we're going to do 733 Salem Street, I assume. Application 2020-2, 733 Salem Street, DeHulu Homes, requesting a variance from the required frontage under the table of density and dimensional regulations in section 8.1. The site is located in the residential R1 and residential R2 zoning districts at 733 Salem Street, Groveland, Mass. Assessor's map 39, parcel 68, proposed subdivision lot 68G. All right, should we proceed with? We want to discuss that application?
Okay, thank you,
As
Mr.
best we can, remote.
Yes, specifically, as you mentioned, lot 68G is what we're focused on, and that references to the definitive plan that was recently approved by the planning board in December. All of 68G itself is located in the R1 zone, which I'm sure you all know requires 150 feet of frontage for a lot. And lot 68G is configured so that its frontage is on Maple Meadow Lane, with 35 feet of frontage on Oakland Terrace. In Maple Meadow Lane and the Oakland Terrace layouts are what were shown on the definitive plan approved by the planning board. Now, Mr. DeHulu is seeking his frontage variance because he wants to allow his access from Oakland Terrace, but that's otherwise prohibited under Groveland zoning bylaw section 8.2.2, which provides in part that frontage must provide access to the lot from the right of way counted for frontage. Where the frontage is actually Maple Meadow Lane. Section 8.2.2, though, goes on further to provide that unless otherwise approved by the planning board on a definitive plan, as we have here, submitted in accord with General Laws Chapter 41 or approved by the planning board in the same manner as a definitive plan, access may be allowed. Now, the planning board did, in fact, consider this, and they granted Mr. DeHulu a waiver allowing his access to lot 868G from Oakland Terrace at the same time as waiving the construction of Maple Meadow Lane. And that's actually noted as waiver 13 on the face page of the definitive plan. And what happened, however, was that this provided a problem that really wasn't contemplated. Since Maple Meadow will never be built and it really exists only on paper, we can't technically use it for access as the term is defined in the subdivision control law and it's understood under the zoning law. Because the frontage doesn't exist, therefore the access can't exist, which is why we need this variance. And really it's kind of a technicality. But to get to the point where the subdivision plan was submitted, there had been several meetings with both conservation and the planning board before that. Originally, it was proposed that the Oakland Terrace and Maple Meadow Lane, and they're shown on this preliminary plan here as Maple Street and Oak Street. They've since been renamed. It was originally contemplated there were going to be 2 lots, each fronting on each street for a total of 4 lots. But after having several of the meetings, it was determined that a better plan, taking more consideration for needs of the neighborhood and the wetlands, would have resulted in 3. So basically, what was approved was Oakland Terrace, which is going to be the only means of the access to the lots. It's about 328 feet in length, extending southerly from Salem Street between houses numbered 729 and 735. At the end of that is a hammerhead. And then Maple Meadow Lane is simply shown on the definitive plan to provide the 150 feet of frontage necessary for that last lot. That's depicted in the plan as being about 193 feet in length, and that extends from Washington Street between residences at 149 and 157 Washington Street. Maple Meadow provides the frontage for only that one lot, lot 68G. The other 2 lots that have their full 150 feet plus of frontage on Oakland Terrace, 68E and 68F, both of those lots conform fully with zoning. They get in excess of the required area and the frontage. When the definitive plan was formally filed, it did expressly state that all 3 of the lots would, in fact, be accessed by Oakland Terrace. The waiver was ultimately granted and noted. And on this plan, you'll see it in the sort of the middle of the page on the left, waiver 13, which was allowed. Now, as I had mentioned earlier in the preliminary meetings before the definitive plan was filed, in the meetings with conservation and the planning board, a lot of thought and time was gone into the engineering and planning and layout of the lots. The entire site is about 8.6 acres. A lot of it is wetlands and buffer zone and poorly drained soils, particularly to the south part of the property and in the area, I'd say closer to Maple Meadow Lane. Originally, in looking at this, and I can let Bill Holt speak to this in more detail later if you're interested, but there was the thought that there could be 4 lots there pretty comfortably. They could have been configured and laid out in a number of several different ways, but ultimately, just because of the wetlands, the neighborhood concerns, they ultimately submitted and sought the 3 plans, which was approved. So after it was all done is really when this issue came up that we couldn't claim that the frontage on Maple Meadow Lane existed for the access. My client did earlier this month apply for a formal building permit, and he was denied because of the access issue, which is what prompted our variance petition and why we're here tonight. Now, as you know, the variance criteria, I could go through those. I'll go through those hopefully quickly. But as you know, a variance can be granted when the board only makes its specific findings for the following criteria. And the first is that owing to circumstances, and I'm reading this directly, relating to the soil conditions, shape of topography, but not size of such land or structures, and especially affecting such land or structures, but not affecting generally the zoning district in which it is located, a literal enforcement of the provisions of the bylaw would involve substantial hardship, financial or otherwise, to the petitioner. In this particular case, we've got the location of the wetlands, the shape of the lot, and the soil as factors that don't generally affect any of the other vacant lots in this particular zoning district, or certainly not in this neighborhood, which really dictate how we can configure and access the lots. When Mr. DeHulu filed for the definitive plan, pretty much simultaneously, he submitted his notice of intent with a Concom. And I did see Mr. Dempsey's icon up on the screen, so hopefully he is going to participate in this meeting. But the Conservation Commission felt, and I don't want to put words in their mouth, but what's being relayed to me is that the Concom, and really the neighbors too, and the planning board really disfavored any construction to the extent possible within the buffer zones, and certainly not in the wetlands. And Maple Meadow is in the buffer zones. And by building out Maple Meadow, there are possibly negative effects to Washington Street and the abutters. And of course, those conditions exist because of the soil conditions and the topography. If we limit the access to this lot solely through Oakland Terrace, we don't affect or impact the wetlands in any way. The house in any grading that will be done pertinent to lot 68G, that's all outside of the buffer zone. So really there was a big concern to try and protect the wetlands. In addition, our particular lot, the whole entire lot, it's a large size, but we can't improve a lot of the area of that simply because of the wetlands. We don't want to, and it just made a lot more sense to create the third lot's access through the Oakland Terrace. Now, the shape of the lot itself is somewhat unusual. I did pull the title to this property a few hours ago to refresh myself with it. This property was formerly owned by the Roman Catholic Church, and in its current or strike that, I should say, in its configuration before my client divided off some lots up on Salem Street and some backland on Benjamin Street. The amount of the frontage on Washington Street and all of the general area that we're talking about remained in the same configuration since at least 1939 when our title exam began. There's always been that 62 feet of frontage. All of the other lots that fronted on Washington Street had been divided off and sold before that time. So in that regard, my client didn't do anything to that real area of the lot as far as making that area more non-conforming or reducing the area that was available to access it through Washington Street in any way. In addition, is another matter relative to Washington Street. There were some safety concerns for the houses generally in that area. There was the concern that by putting another road opening on Washington Street, any traffic entering and exiting through what would be Maple Meadow Lane might not be a good thing for the neighborhood, even though it is a long straightaway down through there. Typically, cars entering and exiting was not really looked at as a favorable thing. So we didn't want to create the extra point of access to Washington Street. It is safer for any vehicles having to go to and from lot 68G to enter and exit onto Oakland Terrace, which will be limited solely to the 3 new houses that my client proposes to construct. And as I do understand it too, the Concom and the Planning Board did discuss this in detail with my client and with his consulting engineer. So ultimately, the layout that we've got for Oakland Terrace provides safe access to and from Salem Street. And by doing that, by having all 3 houses too entering onto Oakland Terrace, we'll ultimately only have 1 road opening onto Salem Street. And again, nothing would be in buffer zones or in environmentally sensitive areas. The proposed use for lot 68G is fully in accordance with what's required under zoning, a single-family use. And if we weren't allowed to access through Oakland Terrace, then in theory, if the frontage can be improved so that there is access on Maple Meadow Lane, there could be a driveway and there could be an access through there. As far as the hardship itself, the hardship caused by the unique circumstances here would cause anybody to be able to or be required to expend an awful lot of money in order to construct Maple Meadow Lane. It isn't just unique or particular to my client. The amounts of money wouldn't be personal. They'd be experienced by anybody, and they'd likely be disproportionate in the context of trying to improve or use some of the other properties in the zone and in the neighborhood. And lot 68G can otherwise be developed consistently with a bylaw, really because of all these factors. Now, the next criteria for the variance, whether desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent or purpose of the bylaw. I think we have that here, and that desirable relief can be granted without substantial detriment to the public good, because the proposed use is really in harmony with and consistent with the zoning plan encouraging single-family homes. And if a variance is granted, you're really not giving Mr. DeHulu or anybody else who owned the property any sort of special rights to use the property in a way that isn't otherwise available to them or violative of the zoning bylaw. It won't be detrimental to the surrounding area. In fact, it's beneficial if we trust in the planning board and the conservation, which did get a lot of input from the abutters, particularly down on Washington Street, who didn't want the access coming through there. And as such, there's no substantial detriment to the public good. And really the effect of the variance will enhance the values of the properties around it. And that's my client's basis for requesting the variance. And if I may, if either Bill Holt or anybody else, or perhaps Steve or Dina has anything to add to that, with the chairman's discretion, perhaps you can supplement what I've said.
Does the chairman wish to hear any more information or description of? Oops. I couldn't hear any question.
Yes, we can certainly, if there's anything explicitly you want to order, we can walk through questions from the board, but if there's anything you want to add before that.
What I'd like to just basically just say is that Maple Meadow Lane could actually be constructed. Actually, we did perk tests for the 2 lots that were proposed off of Maple Meadow Lane originally. So, and there's room to put another second house out there as well. It would have more impact on the buffer zone and more impact on the neighboring community, be more trees removed and more grading done. But it certainly could be built. But this was a better solution to provide less impact to the environment and to the abutters. So this is what we proposed, and it was pretty receptive, pretty much received pretty well with the abutters and with the Planning Board and Conservation Commission. So we think it's a better solution versus building the road itself. So that's basically why we did what we did, why we proposed it as we did it. If there's any questions, specific questions, I can answer them.
Yeah, do we have, if anybody on the board have any specific questions?
Jason, I have a quick question. This Kathy.
You are on the board.
Yes. So I just want to make sure that I'm understanding exactly. So there are 3 houses altogether that are going to be built, correct?
Yes.
Is one of them existing already?
No.
Okay, so there would be, so the one that's on Salem Street currently, that's one, right? The 735?
Yep, that has frontage on Salem Street.
Yep, okay. And then 68F is the second lot, correct?
Yes.
And then the third lot is 68G, which is the one that needs the access.
Nope,
Right.
nope, I'm sorry. Nope, that's the house that's on 735 is an A&R lot that was split off originally. That one's a separate lot, not part of the subdivision. The two lots off of Oakland that have full frontage on Oakland are 68F and 68E. Those 2 lots have frontage on Oakland Terrace, 150 feet, and then some. And then 68G has 35 feet of frontage on Oakland Terrace to be provided access off Oakland Terrace, but it has legal frontage on Maple Meadow Lane. So the 3 lots, 68E, F, and G.
Okay, thank you for clearing that up. It was a little, I think E was the one I was getting confused about. Okay, thank you.
Okay.
So can I add something quickly, Mr. Chairman? I'm not sure if you know, but the meeting time that we have is 40 minutes based on what the town purchased through Zoom. And I think
Okay.
we're running up against that. So I think I believe we have like 7 minutes left. So if we could just move it, is there anyone else that has any other questions that maybe, or anyone else on the board?
Nothing. Pretty quick.
I'm all set. I'm fine.
Okay, because I think maybe we should open it up for public comment if there's any other abutters or Mr. Dempsey or anyone else that would like to speak in favor.
If this is the appropriate time for public comment, I'd just like to introduce myself. I'm Steve Brown. I'm an abutter at 32 Benjamin. Good
Welcome.
evening.
Yep.
So I don't want to tie up anybody's time more than necessary. I understand you're up against the time requirement. I just had a question for Mr. Perry in citing the first conditions for, I believe it was hardship due to topography or financial or otherwise. And there was a description of the existing property that was originally the Roman Catholic Church's property. And I think there was a description about, or a narrative about how that wasn't necessarily modified outside of when it was originally zoned in 1939, maybe with the few exceptions of some properties that were sold off along Washington Street. But it's my understanding there were some modifications to the existing 32 Benjamin and a couple of A&R lots on Benjamin Extension, and maybe you could just talk about that real quick.
Yes, if I wasn't clear, I was really referring to the area specifically closest to the Washington Street and where the Maple Meadow was, but you're absolutely correct. Originally, it was the Roman Catholic Church piece, which comprised the bulk of everything that the DeHulus had. And in addition, they had owned, where their principal residence was, a long strip down along Benjamin Street, and they did reconfigure their two abutting parcels. They increased, I'll say, the backyard depth of 32 Benjamin, where you live, their former residence, and they did create two lots further down on Benjamin Street, and there is one approval not required lot up at the corner next to Knight's Garage that was also divided from the Roman Catholic Church lot. So you're correct in that regard. I hope I didn't mislead anybody. I was really attempting to portray that all of the area down in Washington Street that we're talking about was really not reconfigured.
Yeah, thank you for that. And I guess I'm just bringing up that issue just for transparency, but then also, you know, I'm formally trained as an architect. I go to public meetings all the time. I help districts and towns build school throughout the Commonwealth, and I'm so very familiar with the planning board's process. And so I think, you know, typically you run into neighbors and community members that are just opposed to every construction that just happens to be going on around them. So I think I typically don't fall into that category, and certainly in this case I don't. We're fortunate to move into the neighborhood with full knowledge of a plan that was happening or was going to happen in the near future. And so I'm not here as an outright opponent to any of this. I just want to be very clear on, you know, what's being sought from the zoning board, that they're fully understanding on what's being requested. And I guess not to vent some personal issues with the planning board, but I think, you know, all these properties in the neighborhood were at some time or concurrently owned by the current applicant. And so I think it's a little unfair to request a hardship given the layout of the property in its current configuration. And to, again, this is probably more for the planning board. And so I'm sorry if I'm taking up too much time here, but I think it's,
Right.
you know,
I'll give you another
we
45.
could maybe argue that it's, you know, outside the intent of the planning board's, you know, long range plan to identify like the long range development of a neighborhood. And so there could be an issue with, you know, with that not being fully transparent. And again, this is more beef with the planning board. And so I just would kindly just request that should this be fortunate enough to go through, to just be overly sensitive to the neighbors in the neighborhood, both current and future, and with that, I'll end my comment.
All right, thank you. If we actually have 2 minutes left, then I think our only option right now is basically I'd like to make a motion to continue the hearing to our next meeting, because we're not going to close this out in 2 minutes.
Could I make a suggestion?
Which
Would we be willing to do a second meeting in April to continue this?
It's up to the applicant. I have no problem doing a meeting in 2 weeks, or
Which would be April 15th at 7:30.
either April 15th or May 6th.
April 15th would work well.
Okay,
All right, then I'll make a motion to continue it to April 15th at 7:30.
second.
All those in favor?
Aye.
Kathy,
Aye.
Chris Goodwin, and John Stokes.
Aye.
Well, that's 3. I'm Jason Norman. I'm I too. So
Thank you. And is there any, not to interrupt, is there any additional information that you anticipate that you might need from any of us that we could forward to you before that continuation?
nothing on my end.
Okay.
Nothing I can think of.
No,
I'm good. I'm fine.
I think it's more just the fact that we just don't have time to actually
tight,
put
yeah.
our motion at this point to formalize it. So
Nope, I appreciate it. Thank you very much. So April 15th, and Rebecca, you'll be able to provide us the new meeting information?
Yes, I will do my best to get you all that information.
Great, thank you.
thank you.
All righty.
I'll make a motion to adjourn at
Second it.
8:09.
Chris,
Seconded. Aye.
Kathy,
Aye.
John,
Aye.
I think that's enough.